Yes.
One more case on individual collective control, and then I'll move on to the next issue, if I may.
Right.
The final case is CSRL, that's SEA SRL, which is in my learned friend's supplemental bundle at tab 4. And the significant point to note about this case is that the only question which the court addressed and answered was about the applicability of the general treaty principles. It didn't look at the applicability of the directive. So if your lordship will, if I can take it quite quickly, the relevant question which was referred is set out in paragraph 30.
Yes.
And your lordship will see that effectively it raised compatibility with the treaty provisions. And so when one comes to 35, in deciding whether or not, so on any view, whether the case concerns a service concession or public service contract, and whether or not in the latter case such a service contract falls within the ambit, and matters which do not influence the reply to be given by the Court of Justice to the question referred for preliminary hearing. So it didn't make a difference for that question. And indeed, if you go to the ruling at paragraph 91 simply addresses the general treaty principles. So it was simply dealing with the application of general treaty principles, and that was the question which it addressed. Well, can I now move to the next issue, which is if collective control suffices, was it present in this case? In other words,
So is this issue 4? Have I got my numbering right?
3A, 3B, or
Yeah.
issue 4. Can I firstly make a point about the time at which that question has to be answered? The relevant time for considering whether the conditions are satisfied is the time of the award of the contract in the absence of special circumstances. That, your lordship will recall, I pointed out to your lordship earlier on this morning in the case of the Commission in Italy, which was at tab 32, paragraphs 29 to 30. I don't ask your lordship to go back to that. And under the domestic regulations, they apply when the contracting authority seeks an offer. Your lordship will call that regulation 5. So, but whether it's when they award the contract or when they seek an offer in respect of it, on either date in this case, Brent exercised no control at all over it, whether by itself or with others. When the contracts of insurance were entered into by Brent, it was merely a member of LAMOR. It was not a participating member, and therefore it had no power to vote in the general meeting, and it had no power to vote in a board meeting. In fact, there were some directors, but they didn't include a director from Brent.
What about Harrow?
Harrow did have a director at that stage. So one of their officers was a director at that stage, but Brent didn't.
So what would the sort of special circumstances which would allow a different time to be taken?
The example of the special circumstances is, for example, the Commission in Austria, which was volume 4 at tab 28, where although the conditions appeared to be satisfied at the date of the award, it was part of a predetermined scheme whereby the shares in the company were going to be sold to, some of the shares were going to be sold to a private sector entity. So the court said it wasn't merely sufficient to look at the date of the award, one might have to see what might happen afterwards in that case.
But wasn't it inevitable that Brent would become a participating member?
If it's awarded a contract of insurance, yes.
Yes.
Yes. But if your lordship thinks about the logic for a moment of where that would take one, assume it would mean whenever somebody wished, it goes back to my point about abuse for a moment. If for example, you wanted to contract with some other authority's company, all they would have to do to avoid the directive would be to give you a share in that company, if you're going to look ahead to what may happen. So in my respectful submission, as I say, the requirement is to look at the date of the award. rather than what may happen subsequently. And well, it's also relevant because if you go back to the point of the control test, which is to see whether or not there is in fact an agreement between two people, essentially, if the position can be satisfied after the date of the award rather than before it, effectively you will have agreements between two persons, even if they subsequently decide to get together about something. So that is my short point. The first short point is that that's the date. But let me look at the position now as if Brent is a participating member.
Yes.
Now, it's relevant, as your Lordship has seen, that the control is over both the strategic objectives and the major decisions of the entity. Your Lordship has seen that from parking bricks, and I don't take your Lordship back to it in a number of other cases. And the answer to that question does not depend merely on the constitutional position, but also on how autonomous in practice the entity actually is. Can I remind your Lordship, in Parking Brixton, which is volume 6, tab 40, the test at paragraph 65 refers to the relevant circumstances as well as the constitutional documents. And the court in that case drew attention in paragraph 67 to the considerable powers conferred on the board with, in practice, I emphasise the word in practice, no management control by the municipality. Perhaps your Lordship just may wish to look at that. It's volume 6, tab 40. If your Lordship will go in the judgment.
Paragraph 65 you asked us to look at, isn't it?
It's tab 40, yes. If your Lordship goes in the judgment to page 8636, in paragraph 67, your Lordship will recall there were a number of features which the court drew attention to in the case of the company in question. And little e on page 8636 was the considerable powers conferred on its administrative board with, in practice, no management control by the municipality. And your Lordships will then see that they emphasise in 68 the very broad powers to manage. It could effectively commit to up to, I think, €5 million or so without prior authority of the shareholders' meeting. And your Lordship will see effectively in 69 again what they emphasised at the end in the light above all of the broad powers possessed by the administrative board. So what they were looking at was not simply the constitutional position, but also the fact that in practice no management control was exercised, and it was the broad management powers which were important. Because what they were concerned to see was how autonomous in practice the entity actually was. And one should just perhaps bear in mind about the facts of this case was at the time of the award, the municipality owned 100% of the shareholding. If you will just go back to paragraph 44. The Lordship will see it was 100% owned by the concession granting public authority. That's paragraph 64. Goes back, that's page 8629. So the fact that one had a public authority with 100% shareholding itself didn't help, because in practice the board was autonomous, had wide powers of management, and could commit up to without prior authorisation up to a significant amount. The other cases to bear in mind, I think, I would invite your Lordship to go back to in due course. So Carpatermo, which is volume 4, tab 26. I don't ask your Lordship to go back to now, but there the municipality had 99.8%, I think it was, shareholding, and that didn't give it the relevant control. And your Lordship will also recall in Association Professional, which was at volume 4, tab 24, the court took the view that even if the entity had to contract as a result of a direction by the controlling authority, the directive would still apply if it had freedom to negotiate the terms or end the contract. Your Lordship recalled that this morning, I was showing Your Lordship.
Just give me the reference.
That's Association Professionnelle, Volume 4, tab 24.
Harrow. Don't
Bear
matter.
with me.
Don't matter.
Sorry, I'll get it for Your Lordship. Yeah, it's paragraph 55. Now, Mr. Sumption said that wide powers of management were not fatal, and he relied on the Codicil decision in that respect. It's important to note about that case, without taking Lordship back to it at this stage, that the decision-making bodies were composed of representatives appointed by each of the relevant authorities. There is no suggestion that their duties were owed to anyone other than the authority who appointed them. There's no suggestion that they owed duties to anyone other than the authority who appointed them. That's, I understand, what the position is in Belgian law, for what it's worth, but there's no suggestion of that. The court also attached importance to the particular legal structure within which they operated. Your Lordship recall the reference to the type of company it was, which precluded the entity from pursuing objectives independently of its shareholders, which precluded it from having a commercial character, and whose statutes ensured, so the court thought, that its interests were aligned with those of its shareholders. It's also relevant that the cable network in question was in fact to be entrusted to a subsector board over which the particular municipality concerned had specific and stricter powers of control, but that was an additional factor. Also, in the commission in Italy, which Your Lordship saw this morning, that's volume 5, tab 32, not only did Mantua appoint the members of the governing body and set its budget, but they also appointed an officer who ran the relevant entity. Now, in my submission, Lamel's decision-making was in practice to be autonomous and to be more autonomous than in any of the cases. It may just be helpful to use the statement of facts and issues, if I can, and I'll give you, Your Lordship, the cross-references to the various parts of the constitutional documents with that, if I may. Your Lordship will find the statement of facts and issues in the core volume at tab 3. And can I firstly invite Your Lordship to go to paragraph 20. And I'll come back firstly in a moment to the power of special direction, but Your Lordship will see firstly Rule 33(1) of the rules, that's at page 254 of the core bundle, provides that whenever any power, duty or discretion is stated by the rules to be vested in Lamel, it's exercisable by the board. And Rule 2.2, that's page 236, provides that any reference to the discretion of the board or to any action to be taken by, as the board thinks fit in the rules, is to be construed as a discretion to be exercised or action taken in the sole and absolute discretion of the board without any fetter or other activities. And my Lord, the powers of the board included the following. It was for the board to determine whether a London authority became a member of Lamel, and if so, on what terms. That's Rule 4.1, page 236. It was for the board to determine the risks against which insurance will be provided and for what premium, as well as the period for which and the terms, the conditions and exclusions and limits, excesses and deductibles upon which insurance and other forms of financial protection may be offered, provided only that participating members have agreed at a general meeting that such covers and other forms of financial protection may be offered. The relevant rules for that purpose are Rules 3, Rule 6, subparagraphs 3 and 4 and 8, Rule 12, subparagraph 1, Rule 16, and Rule 19, subparagraph 1, and they're at pages 236, 239, 243 and 246. The period for which an indemnity is normally to be granted is a year, but a participating member is required to apply to renew its indemnity. I emphasise for the purpose of control, it's required to apply to renew its indemnity on or before the end of the period of indemnity, unless 6 months' notice to terminate is given. The indemnity will continue on the same terms unless the board has decided to terminate the authority's membership or the board decides to change its terms, in which case the indemnity will only continue on such terms as may be agreed. Well, that's Rule 10 at page 240 to 241. The board may at any time during or after the end of any financial year, provided it's not being closed, require each participating member who received an indemnity in respect of that year to pay one or more supplementary calls, provided that no such member may be required to pay more than 100% of the premium paid in that year. That's Rule 12, subparagraph 3, page 243. And such calls may be used to meet claims and outgoings in respect to that year, costs and expenses of arranging insurance or reinsurance contracts or transfers to reserves or provisions as the board considers it prudent to make. That's Rule 11, subparagraph 1, at page 241 to 2. Rule 4 refers to the capital contributions, and that's a reference back to paragraph 16, if your lordships will just go back to that. The Articles of Association, the rules provide for two types of capital contribution: a paid capital contribution and a guaranteed capital contribution. A paid capital contribution is payable by a member or participating member prior to, on or after admission to the mutual, whereas a guaranteed capital contribution may only be required of a participating member on or after admission to the mutual. It's for the board to determine the type of capital contribution required, its amount and the time at which it's made, and in the case of a guaranteed capital contribution, the form in which it's to be made. Now, the relevant provisions there are in the Articles of Association, Article 3 at page 196, and in the rules, Rule 3, which is page 234 to 5, Rule 12, subparagraph 2, and Rule 13, subparagraph 1 at page 243. If I can then invite your lordship to go back to paragraph 21. 5, it's for the board to determine what reserves to maintain. That's Rule 29 at page 252. It's for the board to determine what insurance or reinsurance to arrange with whom and on what terms. That's Rule 28, page 251. It's for the board to determine how LAML's funds should be invested. That's Rule 30 at page 252. And it's for the board to determine if any paid contribution should be returned. That's Rule 30, subparagraph 5, page 253. And the board may delegate any of their powers to committee or committees consisting of one or more directors or other persons as they think fit. That's Articles 43 and 44 at page 204. Now, as your lordship will recall, the interests of LAML are not aligned with the interests of any particular member, and they may conflict at times. I gave your lordship some examples earlier on when I was dealing with insurance matters. I won't repeat those, but the power also includes the power to eject a participating member from membership altogether. That's the Articles of Association, Article 11b at page 198. That's about the powers, and your lordship has seen how the board is elected. Can I emphasise that the people who were elected by the participating members. They do not serve as a representative of the authority, and they couldn't possibly take instructions from their employing authority as to how to discharge their duties. They owe their duties to the company. It's quite true, as Mr. Sumption pointed out, I think it's page 202, that they have to cease to be a director if they cease to be employed, but that doesn't mean that they have to do what they're told by their employing authority. Now, more against that background, the board's intended autonomy is illustrated by the very limited powers that the constitutional documents give to those able to vote in a general meeting. Can I draw attention to three aspects of that? Firstly, the only prior authorisation the board requires relates to the nature or categories of insurance cover that may be offered by LAML. not the terms on
Could you
which,
say that again, Mr. Harrow?
the
Sorry.
nature or categories of insurance cover that may be offered. Not the terms on which or the persons to whom the insurance may be offered. Yes, that's the only prior authority they need. So the board's powers are thus far less constrained by any requirement for prior authorisation than were, for example, those in Parking Brixton. There is no limit, for example, on what the board may commit LAML to without prior authorisation, as there was indeed in Parking Brixton. Secondly, a simple majority of members or participating members could not direct the board what to do. Unlike Codital, the exercise by the board of its powers was made subject only to a prior direction given at a general meeting called on 21 days' notice by a majority of not less than 75%. That's paragraph 20 of the Statement of Facts and Issues. So the powers of a majority of members or participating members were less than the powers which a majority of shareholders may have in a company, which of itself is not necessarily sufficient to establish the necessary degree of control.
Now, did you say paragraph 28?
Of the Statement of Facts and Issues, sorry.
I think it's paragraph 20.
20, yes. 20, that's the reference to the 75% special resolution. I don't think the Madame Premise assumption took your lordship to it.
No, it's just checking the number of the paragraph.
I'm sorry. So their powers were less than those authorities involved in Brutale, where decisions were by a majority. There was furthermore no provision requiring members or participating members to be informed of decisions which are under consideration, which might enable such directions to be given. That is of considerable significance in practice, since such resolutions can only be prospective, not retrospective in effect. Thirdly, the board's autonomy is board's autonomy is further illustrated by the fact that any alteration to the rules involving a variation to a member's obligations concerning capital contributions could only be made by a resolution of the members in ordinary meeting if the board had first approved it. Your Lordship recall, I think this assumption took the Lordship to that under the articles. In other words, the board could veto a change in the rules governing a member's obligations about capital contributions. Now, the notion that an entity may veto decisions of the authorities alleged to control it, or that it may disregard what a majority of those authorities may want it to do, is, in my submission, incompatible with the notion that the authorities have collective control over it. It's, in practice, intended to be a board with autonomy. And if one was to approach the question, which the court did in Association Professionnelle, which is, does the entity have a power to negotiate the terms or bring the contract to an end, it's quite plain that Lamour did have the capacity to negotiate the terms. It fixed them. And it did have the capacity to bring the contract to an end, if it wished to. So if one's looking at that, it's plain there were two parties involved. But the matter in practice didn't stop there, because the board delegated the management of Lamour to Charles Taylor Consulting Limited under a management agreement. This is analogous in some respects to the interposition of a holding company in Carpaterno in making any collective control the more tenuous. Now, Charles Taylor were instrumental in the formation of Lamour, and I have to say the first contract to them was awarded without any competition. Your Lordship will find it in part 4 at page 990.
Are you suggesting there's something wrong in principle in having a company like CTC involved in the management, or is something special about the way in which they were actually involved?
Yes, the point which Lord Justice Stanley Burnham was making about this was that one wouldn't expect the local authorities themselves concerned to have the expertise to run an organisation such as this.
Yes.
And effectively, in practice, what we'd like to happen, as this shows, is the management is effectively going to be exercised by Charles Taylor Consulting in many respects. So it's an attenuation of the control which they might otherwise have been able to exercise. It's an illustration of how autonomous the operation of LAML was in respect of its controlling authorities. That's the only point. I'm not saying there's anything wrong in it intrinsically at all. Your Lordship will see that it's on page 990. I need to deal with this quite quickly, I'm afraid. Your Lordship will see at contract begins page 990. If you go to page 994, 3.1, LAML were appointed the exclusive managers, and under 4.1, the managers will, subject to any directions or instructions of the board and to the terms of the agreement, promote, manage and protect LAML and its affairs and operations. So effectively, subject to anything which it was told or limitations, it was to manage LAML's affairs. That was what it was there for. And under clause 7.2a, effectively there's an automatic ratification of whatever they do in that context. And I should perhaps say there's no evidence that the members or participating members have ever been actively involved, I think, in decision-making on LAML or given any directions as to how or within what limits or constraints its business should be conducted. Mr. Sumption made a number of points. The first one, of course, was about control, the voting rights, share ownership and the presumption. Well, if there is a presumption about that, it is a very weak presumption. In Parking Brixton, the share ownership was 100% by the controlling authority. In Carpetomo, it was 99.8%. So if there is a presumption, it's fairly weak. Lord, I've dealt with the wide management discretions. I won't come back to that. Or perhaps I can move on. So I want to try and give Mr. Sumption as much time as I can. And hopefully give him more than the hour if I can manage that. Can I now turn to the second condition in TECL? That's to say whether the activities are conducted essentially with any controlling authorities.
This is the last issue, is it?
Yes.
And it's a function test.
It's a function test, and I'm not going to take very long about it because I want to try and give my learned friend as much time as I could. Your Lordship recall that the condition is that the entity in question must carry out the essential part of its activities with the local authority or authorities which control it. As Your Lordship has seen from Carpetomo and the Commission in Italy, any other activity it may undertake must be of marginal significance. That was the phrase. The references in Carpetomo, volume 4, tab 26, paragraph 63, and the Commission in Italy at tab 32, paragraph 31. And Your Lordship will recall that the requirement is aimed particularly at ensuring that the directive remains applicable in the event that an undertaking is active in the market and therefore likely to be in competition with other undertakings. That's its purpose. Well, the onus of showing that the other activities are only of marginal significance lies on those who assert it to be the case. That's, in this case, Harrow. Your Lordship will see that from the Parking Brixton case. Now, LAML was in the market and competing for contracts for insurance from other London authorities who did not exercise any control over it, and from affiliates who had no control at all over it. Now, so far as London authorities are concerned, Your Lordship knows there were 10 members of LAML. None of them actually controlled it, only the participating members would have done. Now, originally, there were two participating members, Brent and Harrow, and in the year to which the claim related, I think it subsequently grew to 3 because Tower Hamlets joined. And I think Mr. Sumption may be right that the following year they may have gone up to 7, but be that as it may. LAML was in the market for contracts for insurance from the Greater London Authority and 32 London Borough Councils. Those are the definitions of the London authorities. And your Lordship will see what they intended to do if your Lordship be good enough to go to part 3 of the appendix at page 899. This is a witness statement by Mr. Phone, I think he's employed by Charles Taylor Consulting, who was originally a director of Lamel and then resigned when the article, the current form of articles, I think, were adopted. If your Lordship looks at paragraph 40, he says, currently Lamel has 3 participating members, the London boroughs of Brent and Harrow, who became participating members on the 1st of April 2007, and Tower Hamlets, who joined Lamel as a participating member on the 1st of October. The London boroughs of Camden, Croydon, Haringey and Lambeth will join on the April the 1st, 2008, and Hammersmith and Fulham on the 1st of July, with then the existing insurance arrangements expire. Kingston upon Thames was scheduled to join the Mutual in 2010. The directors and managers of the Mutual are in discussion with a number of other London boroughs who have expressed interest in joining the Mutual. So they would try to get work from all the London authorities. There are 32 borough councils, and the Greater London Council also falls within that. So even if one assumed that the member authorities, the 10 or 11, were controlling authorities, which they're not, that would still leave Lamel looking to get insurance from 22 other London authorities and the GLA, which can scarcely be assumed to be of only marginal significance. Can I then look at the affiliates? Whether or not the affiliates are helping to discharge any authority's functions is irrelevant for present purposes. The relevant question is whether any affiliate was a controlling authority in Lamel's case, and plainly it wasn't. I mean, it's obviously not. The question is whether or not Lamel's activities with such bodies, by themselves or taken with its other activities, were only of marginal significance. Now, such affiliates included bodies responsible for schools and for housing estates. They will no doubt have significant assets to insure. Again, other companies than Lamel would compete for their contracts if given the chance. And there is nothing to show that such contracts will be of marginal significance generally, nor indeed in relation merely to Harrow or Brent. So collectively, Lamel was seeking to obtain insurance contracts from 32 London boroughs, the GLA, and all their so-called affiliates. And there is simply no evidence which would support the suggestion that those activities would only be of marginal significance compared with the insurance contracts with Brent or Harrow, who were the only participating authorities at that time, or indeed with the members of Lamel at that time. Moreover, Lamel's activities were not limited by its memorandum even to activities of assisting London authorities and its affiliates. In part 1 in the memorandum of association at page 181, can I just remind your Lordship of little paragraph Roman numeral 10 and 11. Your Lordship will see that gave Lamel power to enter into any partnership or arrangement in the nature of partnership, joint venture, cooperation of union interest, profit or loss sharing arrangement or other association or relationship with any person or company engaged or interested in or who may become interested in the carrying out or conduct of any business which the mutual is authorised to carry on or conduct, or from which the mutual would or might derive any benefit, whether direct or indirect, and to take otherwise and so forth as shares. And then in 11, to establish, promote, or join the establishment or promotion of any other company in any part of the world whose object shall include the taking over of any assets or liabilities of the mutual, or the promotion of which shall or may be calculated to advance its interests, and to acquire, hold, sell, deal with shares of any such company.
Well, these are very broad, but we have to read that with the rider halfway down page 182.
Of course one does, but the position is they have very wide powers to look for commercial opportunities if they're of benefit to the mutual. And in my respect, Commissioner, one simply can't take it that those provisions are a dead letter and were not intended to have any effect. Your Lordship will recall, my learned friend Mr. Sumption took you to the management agreement under which the managers, Charles Taylor, were to assess commercial propositions which may be offered to Lamel and to advise on which such propositions may be accepted. That was clause 4.1f. And to advise the board on the development of existing new lines of business. So it was plainly intended to be more than simply a company ensuring London authorities and their affiliates, unless one is to believe the memorandum is a dead letter. But as I say, on this issue, the onus was on Brent to adduce evidence to show that the activities were only of marginal significance, and they did not do so. Lord, can I then finally, and this is finally, deal briefly with the question of a reference?
Yeah.
Of course, the question of a reference doesn't arise, if your Lordships were with me, on the basis that the regulations don't include exemption anyway. But if your Lordships are against me on that, we have suggested a series of questions which are set out in the Statement of Facts and Issues, which is tab 3, in paragraph 35. And can I briefly, before looking at each of them, can I briefly remind your Lordship what the relevant test is in terms of a reference?
I think we know that pretty well.
You know that? It's the pure fit test.
We don't need to.
Yeah, okay.
By what page you just referred to?
It's paragraph 35.
Paragraph 35.
Of your printed kit?
No, the Statement of Facts and Issues.
Oh, sorry.
Oh, I'm sorry, that's where they're set out.
Yeah.
The first is about whether contracts of insurance can fall within the technical exemption. Your Lordship may recall that Lord Justice Pill pointed out in the Court of Appeal that the Court of Justice had not yet had to consider any case where there may be a conflict of interest between the contracting authority and the entity with whom it contracts. And that is in fact true. They haven't had to do that. And it's still true. That's an important question about how that may interrelate with the technical exemption. The second question is about individual and collective control. Now, there has been no case which determines whether collective control is sufficient to exempt a contract from the public sector directive. Indeed, but for Coditel, Mr. Sumption accepted that the matter would not have been at clare. However, that case does not deal with the application of the directive, and as I showed your Lordships this morning, it didn't address the directive and its terms. So that's the second question. The third question is designed to deal with the features of this case, about whether, if collective control is acceptable, whether it could be met given those features. Can I say that's the type of question which the court has addressed, for example, in Parking Brixton. The fourth question is about EC in Germany. This was to reflect the original contention which both Brent and Harrow were going to advance, whether it's a general principle that cooperation between local authorities should not as a matter of rule be subject to the EU public procurement regime, and if it is, in what circumstances of contracts between local authorities and award would otherwise be within the scope of the directive, exempt from compliance with the requirements imposed by that directive. Now, Lord, originally I had thought that Harrow's case didn't go that far, but on occasions Mr. Sumption's submissions clearly did. What I would say about the Commission in Germany is it's plainly not a TECL case. Whatever else it is, it's not a TECL case. And hitherto, the case has been fought on the basis that the only exemption is the TECL exemption. I'm not taking a pleading point about this, but I'm simply making the point that if your Lordships were to think that there's some more general principle embodied in the Commission in Germany decision, which is what this refers to, that is patently a matter which is not at clare about what principle it establishes, if your Lordships reject the submissions I've made about what it did in fact establish. And so in my respectful submission, if your Lordship is minded to think that that case may be irrelevant in this case, that would also be a matter which is appropriate and right for your Lordships to refer to the Court of Justice.
Where's the quote from in para 4?
Well, that was how Brent and Harrow put it forward to us about what they said they were going to suggest that the Commission
What's in
Journalist.
that printed case, is it?
I'm not sure it's
I see, okay, don't worry.
No, I've got there.
Don't
It's
worry.
their petition for leave, I think, included it.
I see.
But effectively, obviously one can come back to the wording of these questions.
Yes.
It's not intended to be final in any particular way. But effectively, it's to raise a question, if your lordships think it relevant, about what Commission in Germany may decide in this particular area.
Just if I can just explore procedure, if we were to take the view that a reference was required, how do you suggest we go about this? That we ask parties within a given time to tidy up the questions that we think should be referred. Would that be the right way to go about it?
I would respectfully suggest that sensible. It's obviously for your lordships finally to determine what questions to ask.
Yes.
But your lordships might think it appropriate to give the parties an opportunity to express a view on any preliminary views your lordship might have about that. There's a further question whether your lordships would want to express any views yourself about those questions before referring it. It's obviously open to your lordships to do that.
Clearly, if we think there are 4 questions, just for the sake of argument, if we thought one was clear and we could simply deal with it, we might just deal with it and focus the ones on which a reference is needed.
Of course, that's a matter for your lordships.
Yeah.
Good. I'm sorry I've rather garbled after lunch through the submissions. Unless there's anything further that I could assist your lordships with, those would be my submissions.
Thank you very much indeed. Mr. Herberg, I think you have an opportunity if you wish to add anything. No, thank you very much. Yes, Mr. Sumption, when you're ready.
My Lords, the main problem about much of the respondents' argument is in our submission that it unnecessarily complicates the issue by addressing what European law treats as a principled question of legal policy on an excessively technical level. It is convenient, I would suggest, to deal with the issues in the order in which they appear in the list in my learned friend's printed case, starting with the question of the incorporation of the Tekal exception into English law. Now, the cornerstone of my learned friend's argument on this point is that the Tekal exception is based on the proposition that there is in substance no contract because there is in substance only one party. And that was not only the foundation of his argument on issue 1, but it is a thread that runs through much of his argument on the other issues as well. And in our submission, that is a completely erroneous analysis of what Tekal is based on. In the context of issue 1, what my learned friend's argument boils down to is this. He says that a quasi-in-house contract is not a contract at all in European law, but is a contract in English law. Therefore, he says, when the English regulations provide that the regulations are to apply to contracts, that's got to include quasi-in-house contracts as well. So in English law, if this be right, you do have to have an express exception for quasi-in-house contracts, because they're contracts, whereas he says that's not the position in EU law. Now, this argument, if it's accepted, has the ironic consequence that the mere fact of directly transposing from the directive to the regulations without alteration the provision which applies these instruments to contracts means that the draftsman has introduced a significant difference between them. Now, in our submission, this reasoning is fallacious. In the first place, Tekal does not say that a quasi-in-house contract is not a contract, either in form or in substance, or in European law or national law. On the contrary, it accepts that a quasi-in-house contract is a contract, but says that it isn't a relevant contract for the purposes of the European procurement regime. If I can ask your lordships, at the risk of inducing serious depression to take another look at TECAL at flag 46 of bundle 7. Paragraph 49.
Paragraph what?
Paragraph 49 of the judgment of the court. Paragraph 49 is addressed to the position in national law. It's treating the question whether there is a contract between two juridical persons as a question of national law, not European law, which is why it's for the national court to determine it. And that is plainly right. There is no such thing as a European law of contract. The existence of a contract depends on its putative proper law, which is necessarily a national law, and the same is true of the question whether the parties to a contract are juridical persons. Legal personality is also, with limited and immaterial exceptions, the creation of national systems of law. The question what characteristics a contract has to have in order to come within the EU procurement regime is a question of European law. But the question whether it's a contract between two juridical persons and valid as a contract is a question of national law. And 49 recognises that. Paragraph 50 then goes on to deal with the consequences as a matter of European law of the national court's conclusion on that point. If the national court holds that in national law there is a contract between two juridical persons, then in most cases that is the end of the matter, the directive applies. But if the two juridical persons who are parties to this contract have the relationship described in the two TECAL tests, then as a matter of European law, the directive does not apply, and neither does the treaty. See Parking, Brixton, Asemfo, Coditel, and so on. Now, the court in TECAL were not suggesting that a quasi-in-house contract was not to be treated as a contract at all, only that it was irrelevant because if the two TECAL conditions were satisfied, it didn't offend the directive's purpose. Now, in Parking Brixton, the Advocate General in my submission put her finger on this point, and the case is at bundle 6, at tab 40, put her finger on that point at paragraph 44 of her opinion. What she said there was that the question whether or not procurement law is applicable depends not only on purely formal criteria, but also on a process of evaluation. For even where both parties to a legal transaction, from a formal point of view, each have their own legal personality, the transaction carried out between them may nonetheless exceptionally be treated in the same way as an in-house operation, insofar as the two TECAL criteria are present. Now, in our submission, no other analysis than the one which I have proposed can explain how it is that the second limb of the TECAL test applies at all, the function test, because that assumes that there is a contract, otherwise you wouldn't get that far. Moreover, no other analysis will explain the way in which the court has consistently applied the TECAL exception in cases directly governed by the treaty, which does not depend for its application on the existence of a contract, as my learned friend acknowledges. Now, for that reason, the TECAL exception cannot be dependent on the question, what is a contract, whether it be answered in substance or in form. Of course, I entirely accept that it follows from the TECAL exception that a quasi-in-house contract is not within the directive, and cannot therefore be regarded as falling within the category contract for pecuniary interest. But that isn't because it isn't in substance a contract at all. It is because, having regard to the objective of the European procurement regime, of which this directive is a part, the expression contracts, although literally applicable, is limited to relevant contracts, relevant for the purposes of the regime. Now, when one turns to the regulations, there is no principled reason why a contract for consideration, which is a direct translation, I would suggest, of contracts for pecuniary interest, should not likewise be limited to relevant contracts. And there is no principled reason why the test of relevance should be any different. One would expect the draftsman of the regulations, when transposing the language, to have intended to transpose the concept represented by the language. If the concept that is being transposed is limited in its original context, then his intention in using the same language must have been to transpose it with the same limitations. Now, the English law rules about what is admissible for the purpose of construing legislation are undoubtedly narrower than the corresponding rules of European law, mainly in the area which concerns the use of pre-enactment legislative history. But both English and European law recognize that legislative purpose is of critical importance, in particular in limiting the ambit of general words. Both systems recognize that general words may implicitly be limited by their legal context. There is therefore every reason to apply a common approach when one is transposing from one system to the other. Now, my learned friend suggested, in substance, that one could readily assume that the draftsman had intended to exclude the Tekal exception because there were other respects in the same general area in which he had introduced changes. Now, in our submission, this is a peripheral point, even if there were other respects in which the draftsman introduced changes. But in fact, there are not. My learned friend's first suggestion under this head was that the draftsman had defined a contract in a way which included service concessions, for example, by inserting the phrase, whatever the nature of the consideration. The argument was that the difference between a public works contract or a public service contract and a concession lay in the nature of the consideration, and in particular, who it flowed from. In our submission, this is a bad point. First of all, because the reason for the special treatment of concessions is not the nature of the consideration, as the decision in Tel Austria shows. It is the legislative history, the drafting history of the directive before it was enacted. Secondly, it's a bad point because in the directive, service concessions are excluded by Article 17, and works concessions are subject to their own rather different regime. The English draftsman simply adopted the identical drafting technique. Lords, the second suggestion to this effect was that the regulations applied whenever a public authority sought offers, see Regulation 5, which he said was an English law concept not to be found in the directive. Now, I should first of all point out that it seems most unlikely that seeking offers in the regulations was designed to have its technical meaning in the law of contract, because on that footing it would be possible to escape the directive entirely simply by framing one's invitation to potential bidders as an invitation to treat and ensuring that any offer came from the public authority rather than the contractor. That's clearly not what is intended. So I would caution your lordships against treating the word offer as being used here as in the English regulations as a term of art. My Lord, in our submission, there is no significance in that point. Finally, there was Mr. Howell's argument founded on Regulation 30, Sub-Regulation 10, namely that if the TECAL exception applied, an actual in-house bid would have to be treated fairly, whereas a quasi-in-house bid would not. Now, this argument is in our submission rather unreal. Regulation 30, subparagraph 10, is, as your lordships will recall, designed to deal with the situation which arises when a public authority with no obligation to pitch its in-house department against commercial competitors nonetheless decides to do so. Now, in that situation, the public authority will voluntarily have submitted itself to the procurement regime and will be held to the obligation to choose the best bid. That's the effect of Regulation 30 sub 10. Now, the argument that my learned friend puts forward is that if the public authority were to decide to submit itself to the procurement regime by pitting its quasi-in-house subsidiary against commercial competition, he says, well, then it wouldn't have to choose the best bid. Now, my lords, that depends on whether a public authority with a right under the TECAL exception not to put a contract out to tender can waive that right, if it wishes, by announcing that it will receive tenders in competition with its quasi-in-house subsidiary. Now, one would have thought that the answer to that question was likely to be yes. Of course, if you submit yourself to the regime, then it will apply to you. Now, your lordships do not need to decide that issue on this appeal, because your lordships are concerned with the question whether these local authorities were obliged to engage in the public tender exercise at all. Your lordships are not concerned with the question what their obligations would have been if they had decided to do so in spite of not having to. Now, my lords, I suspect that between us, my learned friend and I have exhausted the question of varies under section 22A and B of the European Communities Act. I will simply, if I may, make a brief point about the case of Oakley and Animal, which is authority for the breadth of, in particular, 22B. The argument that the Court of Appeal was dealing with in that case was that section 22 could not be used to implement an option conferred by the directive, but only an obligation or something related to an obligation. What had happened in Oakley and Animal was this. I don't think your lordships need to turn it up, I'll simply give you the references, but it's at bundle 3, tab 17. The directive being considered there harmonised national legislation relating to design rights, and it contained an express right of derogation which allowed national governments to retain in force existing legislation on the subject if they chose to. When transposing the directive into English regulations under the 72 Act, the United Kingdom exercised that right of derogation by including transitional provisions in the regulations which retained in force the existing legislation so far as it related to design rights that had already been registered, so that it would only operate in relation to future registrations. And what was being argued was that it couldn't do that. It was void. It had to apply the new rules either to all registered designs, including those already registered, or to none. Now, the argument was therefore to that effect, and your lordships in due course will find that Lord Justice Waller sets out the contention which the Court of Appeal was rejecting at paragraphs 24 and 25 of his judgment. And Lord Justice Waller's ratio, which is mirrored in the judgment of Lord Justice May, is summed up at paragraph 39 of his judgment, in particular between letters E and F. And it was that the inclusion of optional transitional provisions serves the primary purpose of implementing the directive. In other words, implementing the directive involves deciding how far to implement it in those areas which are left to national discretion. The alternative was the absurd proposition that if the directive said you can do either A, B, or C, then you couldn't do any of them as a matter of English law without primary legislation, because none of them represented obligations. Now, that is a world away from what is involved here, which is the suggestion that the draftsman has applied a directive in the regulations to a category of transaction that are not even covered by the enabling provisions of the treaty, let alone by the directive itself, and are not the subject of any option conferred upon national governments by either instrument. My Lords, I turn therefore to issue 2 about insurance, which I will deal with quite briefly. Insurance differs from the generality of transactions in that the existence of 2 parties is not just a prerequisite to the existence of a contract, it's also a prerequisite for a transfer of risk, which is inherent in the nature of insurance, and would be even if one could imagine a situation where an insurance was not contractual. Now, my learned friend says that since TECAL is based on the need for 2 parties and treats a quasi-in-house contract as no contract at all, it can't apply to insurance. Now, in our submission, that is a reversion to the fallacy underlying his first submissions on the first issue, which I dealt with a few minutes ago. The European Court of Justice is perfectly well aware that there are 2 parties in law. There is a contract, and that is enough to make possible the application of the TECAL exception to contracts of insurance, just as it's enough to justify them being applied to any other contract. The connection, however, between the 2 parties is the thing which may take the transaction outside the category of relevant transactions. And a contract with a captive, as Lord Justice Burnton pointed out, would be a perfectly sound example of that situation. Now, my learned friend's argument under this head was essentially that there was an inherent conflict of interest between an insurer and his assured, which was not consistent with their interests being sufficiently identified as a matter of commercial reality any more than as a matter of strict law. Now, in our submission, that is no truer of insurance contracts than it is of any other kind of contract which a public authority may conclude with a consortium company when it belongs to the consortium.
Is that because if one has anything to do with performance, on the one side, somebody may be seeking to minimize the expense to him and obtain the maximum profit, whereas the other one is looking for the best return on the money that it is investing. And there's
Indeed, that is exactly right, my Lord. In any consortium of public authorities, the generality of participating authorities may, in theory, have an interest in ensuring that nobody gets an extravagant deal at the collective expense of the rest. But apart from that, which is a common factor in substantially all consortium cases, whether they're concerned with insurance or not, there isn't a conflict of interest in the making of the contract of insurance. And that is true whether the product is insurance, cable television, heating equipment, or the supply of stationery. There is, I accept, a potential conflict of interest in the handling of particular claims. But it is the case that all members of a consortium have a common interest in ensuring that claims are processed objectively.
You may come to this in a moment, but we know that under the rules, the participating member whose claim is under consideration is put into bulk, as it were, and can't participate in any board meetings or whatever else it is.
Yes.
But that's probably on issue 3 rather than issue 2.
Well, Lord, it's I would suggest more likely to be under this issue, but whichever pigeonhole one puts it into, that is simply a procedural provision which is designed to ensure that claims are processed objectively, without fear or favour, and that is something in which all the members have a common interest. And that is the reason why the rules provide for claims, in fact, normally to be dealt with by the manager, but for the representative of a claimant authority, if the particular authority happens to have a representative on the board, not to participate in the consideration of his associated member's own claim.
And the common interest is?
The common interest is in the objective treatment of claims by reference to their intrinsic merits rather than to the relationship that the insurer has with the claimant.
And can you clear my mind on one other thing? You mentioned, I think, it must have been on Wednesday, that there would be reinsurance against liabilities. That really stands to reason. Is that really doesn't play any part in the reasoning you're putting forward, does it?
It doesn't.
Can you explain why not?
Well, like most mutuals, this one is a combination of self-insurance and reinsurance outward. The insurable interest that LAML has got in being able to reinsure arises from its liability under the insurance contracts with its members. And what is happening here is that the members are, or the participating members, are collectively self-insuring up to a point, and beyond that point are collectively procuring through LAML insurance on the market. And they do that complying with all the requirements of the procurement directive. Now that isn't the legal analysis, but it's the reality of what's happening.
And the procurement exercise is no different, you would say, from any other procurement exercise.
Exactly. The collective arrangements of this kind are essentially designed to enable efficiencies to be achieved. They may or may not achieve that purpose, but that is the objective. Now, your Lordship's asked, does the creation of a mutual effectively shut out the possibility of contracting on the market? Well, the answer is it doesn't, but clearly it gives a very substantial incentive to ensure within the collective arrangements, particularly in a case where there are capital contributions involved. My Lords, may I turn to the question of collective control, which in my submission is the decisive question.
Is what?
Is the decisive question. Now, on this issue, the European Court's decisions are in our submission directly against the respondents, and it was sometimes difficult to know whether my learned friend Mr. Howell was criticising them or distinguishing them, only the latter being a relevant exercise in a national court. The main argument appears to be that the European Court cannot have meant to say that collective control satisfies the TECAL test in a case where the directive applies, because, he says, it's a basic principle that a contract is not removed from the scope of the EU procurement regime simply because it's a contract with another public authority. That was the point he made on Thursday. And the point he made this morning, because it would be inconsistent with the terms of the directive and with the underlying purpose of the directive. Now, my Lords, the short answer to this is that the European Court unquestionably has laid this down, notably in Asemfo and Coditel, though much more clearly in the latter case than in the former. It has done it on the footing that the TECAL exception applies equally to directive cases and treaty cases, and that it is inherent in the TECAL exception that collective control satisfies the control test. Now, my learned friend took your lordships through the cases this morning, and I took your lordships through them last week. TECAL was a consortium case, we agree about that, in which the Commune of Vienna had less than 1% of the shares of the relevant consortium company. Manifestly, therefore, it had no control alone. Paragraph 50, as my Lord Brown pointed out this morning, refers to the possibility of multiple control when it says or authority or authorities.
Well, what I point out was actually that is confined to the second test.
Well, my Lord, that is so, but as your lordships will recall from the other cases, these two tests operate together. And the second test is that the essential part of your business is conducted with the people who control you. And as we've seen, particularly in Coditel, the one goes with the other. If collective control is sufficient, then the question is, one, do you collectively with the other members have control? And two, does the entity conduct the essential part of its business, not with the individual contracting authority, but with the collectivity? My lords, by far, my learned friend says that the probability must be that the European Court thought that this particular transaction would fail the control test, which is, he suggests, why they didn't refer back the function test to the National Court. My lords, by far the most likely reason why they didn't refer the function test back to the National Court is that there was no issue about its application. There certainly is no trace of such an issue in the report or the opinion of the Advocate General. It is most unlikely that the court declined or failed to refer the second test back to the National Court because they thought that the whole transaction was bound to fail. That would have been a reason for not referring anything back to the National Court and simply saying the facts before us show that this one can't succeed. My lords, Carbo Termo...
Just before you leave TECAL, Mr. Sumption, I wouldn't mind. In 50,
yes.
When we were reading through it again, he pointed out the singular in the third last line, it exercises over its own departments. And the picture he was presented was an examination of the relationship between the particular authority, which is one of the participating members, and to see what its own position was in relation to its own authority and so on.
Yes.
And he says, well, if you confine your examination in that way, that could produce a different result from the collective one, and you can't shelter behind the collectivity.
Yes. Well, my lord, that is something that should caution us against attaching too much importance in the interests of either side of this particular argument to a single phrase if one isn't satisfied that the particular issue was before them. All one can say with confidence about TECAL is that because it was a consortium company, they must have envisaged that it was in principle capable of being satisfied by a consortium company. Although, of course, unless there is a wholly dominant member of a consortium company, and undoubtedly the Commune of Vienna was not a wholly dominant member, unless there is one, on my learned friend's argument, this would never actually be an exception that was available.
Well, I think the point may be that there are some cases where it really doesn't matter at all.
Yes.
And there may be some where it does.
Well,
and
exactly.
Mr. Howell's position, as I understood it, is that in this case, if you analyse it that way and take the thing through into the detail, there are good reasons for saying it does matter, and therefore you really do need to know whether you're bound to focus on the individual authority or whether you can, as I put it before, shelter behind the collectivity.
Well, I would accept that there are some cases in which it matters. I mean, Carbo Termo was a classic example of a case where it didn't matter, because Carbo Termo had 99%, in round figures, of the voting rights in the consortium company, so that whether it was individual or collective, subject to a particular factor, which explains why Carbo Termo actually failed, or why the transaction failed, but subject to that particular factor, the possession of 99% would normally carry the day. My Lord.
So, more than one authority have this relationship.
Yes.
Separately with the...
I think it's implicit in my learned friend's argument that more than one authority cannot.
Yes, that's why I'm asking.
Because
That's what I'm wondering.
Well, except in a case like sort of a SEMFO, where you've got these autonomous communities, each with only a 0.25% shareholding.
yes,
But there they do have control because they're entitled to the service and nobody can charge more than stipulated.
well, my lord, I'm not sure that that is in fact. I'm going to come to a SEMFO, the correct analysis of that.
Well, no, but I mean, that's his case, as I understand it. I mean,
My lord, it was the case
don't have much
in a SEMFO that, and it's the reason why there was no contract. It was the case that there was a public law right to the services of Tragsa on demand at a price which was determined by law.
Yeah.
Now, I'm going to come to a SEMFO, but in my submission, it's not correct to regard that as control. You don't normally treat a company as controlling another, or an entity as controlling another, simply because he has a right, whether it is based on public law or contract, doesn't matter, to the services of that other. If I have an option, contractual, to demand at a fixed fee a particular service from a company, that means that I have the degree of control necessary to make that company supply me the service. It doesn't mean that I control the company as an entity. And in my submission, SEMFO was not suggesting that. They were rejecting, admittedly in a very brief paragraph, the proposition that had been advanced that only the Spanish state, because of its 99%, had got a sufficient right to constitute control over the entity. And when one looks at the subsequent cases, in particular Coditel, that is the proposition for which SEMFO is cited as authority. It's cited as authority for the proposition that collective control is good enough, and I will come to that in just a moment. But Carbo Termo, as I've said, on its facts, is not much of a test of collective control because of the very large proportion of the shares which the relevant contracting public authority had got. And that is the reason why the analysis of the facts concentrates on the particular position of the commune of Busto Arsizio, as Mr. Howell quite correctly pointed out. But that is simply because in that particular case, the commune of Busto Arsizio, on any view, had shareholding control. Now, in Carbo Termo, however, the same point is made, and again I make this point with due reservations about not attaching excessive importance to stray phrases. But at paragraph 37, your lordships will find, as my learned friend pointed out, and as Lord Justice Burnton pointed out,
Paragraph what?
paragraph 37
Of Carbo
Termo,
And this
the
is
reference to exercising control alone or in conjunction with other authorities.
Could we just look that up, please, just to be
yes,
quite
of
sure?
course. It's flag 7.
Yes.
Flag 26 of bundle 7.
Bundle 4. Is it
Sorry, bundle 4.
And it's paragraph 37, you said.
That is right.
Yeah.
Point which is made here is the fact that the authority holds, alone or together with other public authorities, all the share capital in a successful tenderer tends to indicate, without being decisive, that contracting authority exercises a control similar to that which it exercises over its own departments. Now that is...
We misread it.
I'm sorry. The fact that the contracting authority holds, alone or together with the other public authorities, all of the share capital in a successful tenderer, tends to indicate, without being decisive, that that contracting authority exercises a control similar to that which it exercises over its own department.
A presumption, which
Yes.
Mr. Howell says is a weak presumption.
Well, my learned friend says it's a weak presumption. I'm not quite sure on what basis, but I'm making a slightly different point here, which is that it couldn't have been relevant whether the contracting authority held these shares together with other public authorities, save on the footing that collective control satisfied the control test.
Satisfied or could satisfy?
Well, all right, could satisfy it, because I agree that there are other considerations as well, for instance, presence of private capital and so on.
Yes.
Now, my Lord, the control test in Cabo Talmo was failed because even with a 99% holding, the constitution of this company did not confer on the shareholder a power equivalent to that which, in this case, is conferred by the special resolution procedure.
It's a fairly striking difference between Tekal and Cabo Termo, that in one, the court sent it back to the National Court when there was 1% in. In this case, the court seems to have said, you're out without sending it back to the
Indeed.
National Court,
And in our
with
submission,
99%.
that is what they would have done in Tekal if they had thought that they were out. My Lord, Asemfo I have largely dealt with in response to your Lordship's questions. My learned friend seeks to explain the analysis in Asemfo on the footing that Tragsa was controlled by all 5 entities that were members because of the public law duty to supply the relevant services on demand at a regulated price. Now, my Lord, in our submission, the fact that Tragsa was bound to do that did not give its members in itself control over Tragsa as an entity. The important point I would submit is the one made in paragraph 59, it's at flag 23 in bundle 3.
Sorry. 3.
Paragraph 59.
Tab 23,
Flag 23, yes.
paragraph 59.
Which is the paragraph in which they reject in terms the suggestion that the condition is met only for contracts performed at the demand of the Spanish state, excluding those which are the subject of a demand from the autonomous communities, as regards which Tragsa must be regarded as a third party. Now, that's the submission that they are rejecting. And it is perfectly correct to point out that in the following paragraph, they refer to the public law duty to supply the relevant service. But what is striking is that when one looks at the proposition for which this case is regarded as authority later, it is regarded, particularly in Coditel, as authority for the proposition that collective control is enough. My learned friend says, when he got to Coditel, this is bizarre and very strange, but it's undoubtedly the case. And
No,
with that
sorry, I'm just searching to where we get the collective control point here drawn out. I mean,
Well, the passage, the part of the judgment that deals with the control test is the part between paragraphs 57 and 61.
yes,
And they start by saying that they start with the presumption that we've referred to before. It's the same as the Cabo Termo presumption. And then they say, in the case of the main proceedings, it's clear that the presumption arises because 99% of the share capital is held by the Spanish state.
yes,
They then say, we are presented with an argument that that means that just the Spanish state
right.
has got the relevant control, and that argument we reject. Now, it's quite true that they make the point, in the same context, that there is a public law obligation to supply the relevant service. But one, I respectfully suggest that that not being a measure of control over the entity as opposed to the provision of the particular contract of supply is unlikely to have been the decisive factor, and that subsequent authority, particularly Coditel, treats this case as authority for a much broader proposition relating to the sufficiency of collective control in this area. My Lords, and that really brings one to Coditel.
Just, sorry, to detain you, because it's rather important to understand that the proposition in 60 would hold equally good for the state.
Yes, it would.
Wouldn't it? But so they're putting the authorities on the same level as the state for what it's worth.
They are. They are putting them on the same footing as it was put in a later decision on the basis that it doesn't matter what the size of your shareholding is. And the reason it doesn't matter what the size of your shareholding is simply that if you are all members of the association, the test depends on what you can collectively achieve and not what one person could achieve with his own shareholding alone. My Lord's Coditel, which is at tab 4, flag 27, is clearly the case which gives my learned friend the most difficulty, and his submissions about it consisted very largely of criticism of the reasoning of the court.
Yes.
Now, this was, of course, the case in which collective control arose directly for decision because it was the very question that was asked in question 3 by the National Court. If one looks at the terms of the question posed, and it's set out in paragraph 22 of the judgment, the
427. Yes, it's 427, and we're at paragraph 22.
Volume 4, flag 27. The question was posed without making any assumption in the question itself about whether the directive applied or not. So it certainly wasn't a question which was asked on the footing that the position might be different as between the two. What the European Court held, and what is in our submission decisive in this case, is, first of all, that the Tekal exception applied whether the matter was governed by the directive or directly by the treaty. It didn't apply by analogy in my submission, it applied. And
Where do we get this?
We get that from paragraphs 24 to 26 of the judgment. In particular, paragraph 25. And that is because the Tekal exception is an exception which is fundamental to the ambit and purpose of the whole EU procurement regime. And although its detailed content may be different when the treaty applies directly, the underlying purpose is the same, and the underlying exception is therefore the same. Now, the important point here is the combination of two conclusions. First, that the Tekal exception applies whether the directive is engaged or just the treaty, that's paragraphs 24 to 26. And secondly, that the control test in the Tekal exception is satisfied by collective control, that's paragraphs 45 to 54. Now, it necessarily follows from the combination of those two conclusions that collective control is enough for both the treaty and the directive. The sufficiency of collective control is expressed as being inherent in the nature and purpose of the Tekal exception. Therefore, if Tekal applies to both, then so does the sufficiency of collective control. And consistently with that, the court refers in its analysis of collective control to authorities which are drawn from both cases where the directive applied and cases where the treaty applied directly. The critical parts of the judgment for this purpose are between paragraphs 44 and 49, and at paragraph 53. They first of all point out, at paragraph 44, that according to the case law of the court, where several public authorities control a concessionaire, the condition relating to the essential part of that entity's activities may be met if account is taken of the activities which it carries out with all of those authorities, and they refer there to a case where the directive applied.
That's the second condition, no?
That's the second condition, but they then go on to say it would be consistent with the reasoning underlying that case law, and it's talking about Tekal, Carbo Termo, Asemfo, to consider that the condition as to control exercised by the public authority may also be satisfied if account is taken of the control exercised jointly over the concessionaire by the controlling public authorities. And they go on to say, according to the case law, the control exercised over the concessionaire by a concession-granting public authority must be similar to that which the authority exercises over its own departments, but not identical in every respect.
Why is it in the singular?
Well, my Lord, I can't answer that question, but it's quite clear that they are not intending to limit it to the singular, because they couldn't have answered the question the way they did.
Well, I think you've got to read the next sentence anyway.
Well, indeed. Though the control exercised over the concessionaire may be effective,
Must be effective.
sorry, must be effective, but it is not essential that it be exercised individually. So what it is saying there is that the singular is not an essential part of the test.
That's the one that Mr. Hull's characterised as a complete non sequitur, I think,
Well,
isn't it?
Well, that's quite right, my Lord, but I mean, jurisprudence, I'm not sure that that's a legitimate point.
It's very weird.
But do you concede it's a non sequitur?
No, I don't.
I see.
Certainly not. I accept that it's right that Mr. Howell said it.
Just say I correctly reported his submission.
Absolutely. But, my Lord, it's a perfectly rational principle. And the reason why it's rational, there are a number of reasons why it's rational, but among them is the fact, and I'm going to come to this point, that the reason why a wholly in-house arrangement where you use one of your departments is not covered is not simply that there is no contract. That would be irrelevant for the purposes of the treaty. It is that an in-house department can be assumed to be wholly associated with the public function of the entity of which it's a department. And what these cases are saying is that there are circumstances, namely those where the two Tekal tests are satisfied, where that is also true of a case where the supplier is a separate entity, but there is a relevant relationship. Now, collective control does not dilute in any way the association of the supplier with the public functions of the public authorities, provided, of course, that only public authorities are exercising the collective control.
Well,
that's the rationale.
Yes, and I mean, I'm intervening there because you remember the point was made that this could lead to abuse.
Yes.
But you say the answer to that is, of course, as soon as you get a private entity involved in this, that destroys the whole scheme.
Well, indeed it does. I would also make the point that in a jurisdiction, and this applies both to the approach of the English courts and to the approach of the European Court of Justice and the Court of First Instance, the concentration on substance rather than form is going to be more than adequate in all cases that one can imagine to ensure that artificial abuses are unsuccessful.
I thought the argument was you can have abuse quite irrespective of any private participation.
Well, my Lord, yes.
If you just confine the whole thing within the public sector,
Well,
you can still abuse it by just having a share here and there.
Well, my Lord, the potential for abuse and for the construction of artificial schemes exists, but one assumes that the courts will be alert to discern the real nature of the agreement. And I would also point out in the context of abuse that the potential for abuse is just as great, so far as it exists at all, in the context of cases governed directly by the treaty, as it is in cases which are governed by the directive. If the ECJ was not deterred from holding that collective control was sufficient in the context of the treaty, it is hard to see why it should be any more deterred by doing so in the context of the directive. And more generally, there is in our submission no rational distinction between treaty cases and directive cases when it comes to the question of collective control. Of course, in directive cases, there is a raft of more detailed and prescriptive provisions about the exact form of the tender and the timing and so on. But as regards the question we're now concerned with, namely the relevance of collective control, in our submission, there is absolutely no difference of principle between them at all. The only difference is that my learned friend says that the directive is based upon the concept that there is really no contract at all, because there are not two parties, whereas he says the treaty is indifferent to the question whether the transaction is indeed contractual. Now, Lord, I've made the point that the suggestion that the directive actually depends upon the concept that there is no contract at all is a fallacy. And once that fallacy is removed, in our submission, there is no relevant difference for the present issue between a treaty case and a directive case.
Could I ask you, just before we leave Coditell, that curious last sentence in paragraph 46, was there really a live issue in that case to which that sentence was directed?
My Lord, it is correct that in Coditell, the form of the question assumed that the function test was satisfied. Is that the point that your Lordship...
Well, it's really this last phrase, it's not essential that it be exercised individually. I'm not...
Oh, well, that is absolutely central to the question that was asked.
Right.
Because question 3 asked, and at paragraph 22, your Lordships will find it, for that control to be regarded as similar,
yes, I see.
must it be exercised individually by each member?
Yes, so it's picking up precisely what the question was.
Exactly. It's a direct answer to the question which the National Court posed. Now, my Lord, my learned friend said very little about the case of Saya and Ponte Nossa, but that case is very difficult to reconcile with his submissions, because your Lordship will recall that that's in our supplemental authorities volume at flag 5. Sorry, flag 4, I'm grateful. And what is clear from paragraphs 34 and 35 of the judgment in that case is that the Court of Justice was embarrassed by the fact, C34, that the decision for reference doesn't contain the information necessary to determine whether it's a public service contract or a public service concession. In the former case, it would be governed by the directive, in the latter case, by the treaty, or in the latter case, whether all the conditions for the application of the directive has been satisfied. In particular, it doesn't say whether the amount of the contract at issue crosses the threshold for the application of the directive.
Why in the latter case?
I'm sorry, my Lord?
Why in the latter case, public service concession as opposed to public... I thought the directive applied to public service contracts.
Public service concession is outside the scope of the directive. I think that must have been...
So why isn't it former case, is my question?
I think it must be the former case, my Lord.
Thank you.
But the point that then immediately follows from paragraph 34 is that having said they can't decide whether it's within the directive or governed directly by the treaty, they then go on at paragraph 35 to say, well, it actually doesn't matter at all, because whether the case in the main proceedings concerns a service concession or a public service contract, and whether or not in the latter case, and there they do use that correctly because they put things in a different order, such a service contract falls within the ambit of the directive, are matters that do not influence the reply to be given by the court. So what they're saying is, we needn't bother to decide whether it's a directive case or a treaty case, because the answer is going to be exactly the same on either possibility. Now, my lords, it's enough for my purposes that is what the European Court has held to be the law, but it is, if I may say so, also a perfectly rational position given the underlying purpose of the Tekal tests. And it's because my learned friend doesn't accept the underlying purpose of the Tekal tests as we have described them, that he has suggested that this is all bizarre and eccentric and so on. The purpose of the control test and the function test is to confine the Tekal exception to cases where the supplier can be identified with the public function of the authorities who it's supplying.
Sorry, is this your submission or the argument you're facing?
This is my submission.
Can you just say it again?
That the purpose of the two tests in Tekal, and particularly of the control test, is to confine the exception to cases where the supplier can be identified with the public function of the authorities that it's supplying. And this concept, which originates with Stadthalle, is that some controlled entities may be as much identified with the public functions of a public authority as that authority's own departments. And that was perhaps the point most clearly made by reference to the decision in Stadthalle by the Advocate General in Parking Brixen. If your lordships would turn to Parking Brixen for this purpose.
That's volume 6, 1040, I think.
That's exactly right. I'm grateful, my lord. The Advocate General dealt with this at paragraphs 67 and 68 of her opinion, where she pointed out paragraph 67 on page 8605, the control which a public body exercises over its own departments is usually characterized in law by the right to give instructions and supervisory powers. Within a single authority, for example, the authority's management usually has the right to give instructions to the department under its responsibility. In relation to subordinate authorities, it also has a right to give instructions. Then at 68, in relation to the managerial bodies of public undertakings, at least where these are organized in the form of a public or private limited company, such powers of instruction or supervision should be the exception. Accordingly, any requirement that the public shareholder should have the same possibilities in law in relation to its contractors as it would have in relation to its own departments would make it almost impossible for the first Tekal criterion to be fulfilled in respect of capital companies incorporated under private law. And if one then turns on from there to paragraphs 72 and 73, in any event, through its use of the phrase control similar to that which the judgment in Tekal indicates, that the possibility the judgment in Tekal indicates that the possibilities open to an authority for exercising influence over its own departments and over public undertakings do not have to be identical. What matters in deciding whether an undertaking is akin to an administrative department or to other market operators is not whether, from a formal point of view, the public body has the same possibilities in law as it does in relation to its own departments, for example, the right to give instructions in a particular case. What matters is rather whether in practice the contracting authority is able to attain its public interest objectives in full at all times. It is only where an undertaking has been made independent to such an extent that the contracting authority is no longer able to pursue its interests in full within the undertaking that the contracting authority can no longer be said to exercise a control similar to that which it exercises over its own departments. The point which is being made is that although a public authority will hardly ever in practice have a legal right to give directions, although collectively, of course, they did under the special resolution procedure here, although it will hardly ever have a right in law to give directions, the practice of the matter is that they are in control of the entity, and that is sufficient to make it similar to one's own department in the respect which matters, which is the quasi-in-house entity as much associated with the performance of its controller's public functions as a department of the authority would be. And Lords, the reason why the Stat Haller itself held that the control test was not satisfied in that case, although there was undoubtedly control in fact, as a matter of German company law, with 75% of the shares, they could do what they liked. But they couldn't pass the control test because of the existence of the minority of private shareholders. In other words, the control has to be of a nature which identifies the supplier with the public functions of the authority. Therefore, the mere existence of private capital, and it could be much smaller than 25%, is inconsistent with it because it attacks the nature of the control at the precise point which is relevant for the underlying policy. And that's the reason why in Carbo Termo at paragraph 37 and in Coditel at paragraph 31 and in other cases also, it has been held that the holding of 100% of the shares by the public authority or by the association of public authorities creates a presumption that the control test is satisfied. That's because when you have that situation, there is no non-public interest involved. And it's the reason why in Coditel, the control test was satisfied in spite of the wide managerial discretion which was vested in the governing council of Brutele.
Could I ask you this? Do we get any insight in this case, we've just been looking at Stat Haller, as to what the court made of the Advocates General's analysis?
Well,
it's
they don't ever refer to it in terms. It's extremely rare for the ECJ to refer to
I can't
the
understand that.
Advocate General
That's why I use the word insight.
Yes.
So one
It
sort of
is,
hints.
it's an inference from the fact that the Advocate General in Stat Haller rationalised the existing case law on the basis of the public functions of the authorities, and that is something that is picked up in Stat Haller. The reference to Stat Haller is Volume 7. Paragraph, flag 45, and in that paragraph, your lordships will find the point is mainly picked up at paragraph 50. In this respect, it must be observed first that the relationship between a public authority, which is a contracting authority, and its own departments is governed by considerations and requirements proper to the pursuit of objectives in the public interest. Any private capital in an undertaking follows considerations proper to private interests and pursues objectives of a different kind. Now, in my submission, that analysis, although more succinct, for which I apologise, is exactly the one that I have just put forward for the Stat Haller case.
Yes. Thank you.
Now, my lords, my learned friend's response is to suggest that these cases were decided or are explicable on other grounds, but since they are not grounds on which the court itself founded their opinion, then that is not in our submission much of a response. He invited your lordships to ignore the first of the two reasons given in Stat Haller for its decision, the one that I have just derived from paragraph 50 of the judgment, although that was in fact the reason in Stat Haller which the court later adopted when dealing with the public interest dimension in Coditel and EEC in Germany. He then invited your lordships to treat Commission in Germany as having nothing to do with Techau, because it was decided on the grounds that Hamburg was supplying no service at all to which the directive could apply. Now, my lords, in our submission, it is particularly difficult to analyse Commission and Germany on that basis. If your lordships have the case at bundle 5 of the authorities bundles, flag 30, the city of Hamburg clearly was supplying a service to the 4 Landkreise because it was undertaking to make available waste treatment capacity. It's perfectly true that it was not liable for any defects or breakdown in the provision of capacity by the operator of the Rugenberger Dam facility, but the contract, as is recorded between paragraphs 19 and 24, provided for other capacity or on specified conditions to be available in that event.
So 19
Between 19 and 24, your lordships will find a number of references to the terms of this particular contract.
This is in the judgment, is it?
This is in the judgment itself.
One finds it 39, certainly.
I'm sorry, Lord.
39, this is what I
39 also deals with that. And if your lordships look at 39, you'll see that Stadtreinigung Hamburg does not assume any responsibility for the operation of that facility and doesn't offer any guarantees. In the event of the facility ceasing to operate or malfunction, its obligations are limited to offering replacement capacity, that obligation being conditional, however, in two respects, and the conditions are then set out. But in that case, what Hamburg was doing was undertaking by contract to procure the availability of capacity at a commercial waste treatment plant, which it had been instrumental in having built.
But what is that? It's not what is that in the way of a supply?
Well, my lord, it is the supply of what they are making available to the Landkreiser is the right to have their waste treated up to a given quantity by the Rugenberger Dam facility, or in the absence of that facility, by a number of other facilities which Hamburg had available.
I know. Does that fall into the directive?
Lord, in our submission it does.
As what?
Lord, it's a service. What one is, it may not be a service which is being provided by the operator of the facility, but it was Hamburg that contracted with the Rugenberger Dam operator. And Hamburg is saying, we will provide to you the right to use this facility. Now, in our submission, a contract by which you procure that someone else will provide you with waste treatment facilities is as much a contract for the provision of a service as a contract by which you say, we will let you have the use of our own personal facility. And indeed, it looks as if Hamburg itself did own the alternative facilities that would kick in if the Rugenberger Dam facility failed. But, my lords, I don't want to get sidetracked into a point that clearly was not critical to the reasoning of the court in this case. Because what happened in this case is that the German government, the Commission was saying that Tekal could not apply because there was no control. See paragraph 19. And at paragraphs 21 and 24, that point is taken up again in a summary of what the Commission was suggesting. They were saying the only relevant exception is Tekal, and it doesn't apply here because there is no control. The German government responded to that by reference to Stadthalle, and they argued that the control test was only a way of giving effect to a right on the part of a public authority to procure goods and services from an entity which was identified with the performance of its public functions. See paragraphs 22 to 24 of the judgment, where the arguments of the Republic of Germany are summarised. And the court, if one turns to paragraph 36 for its own reasoning, the court accepted that there was no control. They say that in paragraph 36. But they then go on at paragraph 37 to say it must nevertheless be observed that the contract at issue establishes cooperation between local authorities with the aim of ensuring that a public task that they all have to perform, namely waste disposal, is carried out. Now, it then, at paragraphs 45 to 47, effectively adopts the German government position based on Stadthalle. At 45 and 46 and 47, they are referring to the public interest dimension, and in particular at paragraph 47, your lordships will see that they are deriving that from Stadthalle. Effectively, they are saying, therefore, that the policy rationale of the Tekal exception is one which does apply in this case, and therefore they could have organised a collectively controlled subsidiary to do this, and the TECAL exception wouldn't have then applied. The Commission acknowledged that, see paragraph 46, so that it was reduced to a point of mere form. And the court said, well, if the rationale of the TECAL rule applies, and they could, by organising themselves differently, have made it apply in point of form as well, then in point of substance, we're going to produce exactly the same result in this particular case. Now, my lords, in our submission, there is no merit in my learned friend's argument that this state of the law is inconsistent with either the purpose or the terms of the directive. In the first place, there is no inconsistency between those decisions and the decisions of the European Court in cases like Conisma, Commission and Spain and so on, which say that the mere fact that a supplier is itself a public authority does not take the transaction out of the scope of the procurement regime, and I accept that. I quite accept that the mere fact that the supplier is a public authority does not take the matter out of the scope of the procurement regime. But there is an obvious difference between a case where a public authority procures goods and services from another public authority and a case where two or more public authorities collaborate to use their collective resources for the performance of the public functions of each of them, normally by setting up a collectively controlled vehicle to supply them. But that is completely different from a case where you are simply procuring your supplies from another public authority with whom you have no other relationship than the relationship of supplier and purchaser. Now, nor is there any inconsistency with the terms of the directive. The provisions relating to central purchasing bodies, on which my learned friend relied heavily, I won't ask your lordships to turn it back, but for your lordships' note, they are defined in Article 110 of the directive and dealt with at Article 11. And those provisions have been directly transposed into the regulations at Regulations 2.1 and 22. Now, collective purchasing bodies, central purchasing bodies, are public authorities which purchase goods and services intended for other public authorities. That's the definition. And the public authority contracting, if a public authority contracts with a central purchasing body meeting that definition, the public authority is deemed to have complied with the directive, provided that the central purchasing body has itself complied with the directive. Now, the point is simply, central purchasing bodies are different from TECAL entities. They will not usually satisfy either of the TECAL tests. Their special treatment in the directive is therefore in no way inconsistent with the application of the TECAL exception to collectively controlled entities. Exactly the same is true of contracts excluded by Article 18 of the directive, which, as your lordships will recall, is an exemption for public authorities having an exclusive right to supply other public authorities, an issue which doesn't appear to arise in this country, but does in, for example, Spain, Italy, and France. Now, my lords, a very elaborate argument was addressed to your lordships this morning about Article 23.2 of the Utilities Directive. What was said is that that was redundant if collective control was sufficient. Now, my lords, in our submission, the Utilities Directive and Article 23.2 has absolutely nothing to do with the case. Article 23.2 applies to what are called affiliated undertakings of a utility. Now, the whole Utilities Directive is not confined to public authorities. It is regulating the procurement activities of utilities, whether they are publicly or privately owned, bearing in mind that in quite a lot of member states they are now privately owned. Now, if you have a utility and it contracts with an affiliated undertaking, there are extensive exemptions available under 23.2. But an affiliated undertaking is defined in 23.1 as being an undertaking in which, and I summarise very broadly, in which either their accounts have to be required to be consolidated with those of the utility, which in general means more than 50% shareholding, or the utility has a dominant influence over the affairs of the supplier, which is something that it may have with very much less than 50%. 30%, for example, if the rest of the shareholding is widely distributed, will normally be enough to give you a decisive vote in the voice in the affairs of a subsidiary. Now, therefore, 23.2 creates a very wide exception, much wider than the TECAL exception, for utilities only. And indeed, there are plenty of cases where you would not be within the TECAL exception, though you might meet 23.2, an obvious example being the existence of private capital. In other words, the whole rationale of the exception of affiliated entities in the Utilities Directive is completely different from that of the TECAL exception, and in our submission, your lordships are not assisted at all by analogies drawn from that situation. My lords, in the end, my learned friend was really relying on a much broader submission to the effect that the acceptance of collective control would invite abuse and evasion. Now, my lords, I've already made my response to that. One, courts looking at the substance of the matter will readily detect abuse and evasion. And two, so far as it is a problem, which in our submission it is not, it is as much a problem about treaty cases as directive cases, to which my learned friend is bound to acknowledge that the TECAL exception applies on the basis of collective control. But if I may deal very briefly, and I'm trying your lordship's patience, for which I apologise, with the application of the control test. In our submission, the control test is satisfied if we are right about collective control. Manifestly, it is not satisfied if we are wrong about collective control. Now, the initial point, the threshold question that my learned friend raised about this, is that he says that Brent was not a participating member until it made a contract of insurance. And clearly the same is true of Harrow. You don't become a constitutional member, i.e. one entitled to participate in the constitutional decision-making process, until you are a participating member by virtue of having a contract of insurance. But, my lords, the category of parties to insurance contracts and the category of controllers is exactly the same, and that is what matters. My lords, my learned friend emphasises, rightly, that it depends on whether in practice the public authority has control and not just in theory. Now, in our submission, it primarily depends on both. You look first at what control is available to the members under the constitution of the supplier. You don't have to show that the rights of intervention were actually exercised. It may be unnecessary to exercise them. There may be complete harmony. But the rights of intervention have to exist. And what you do, see Carbo Termo and Coditel, is that if the public authority has the entirety of the voting rights, or the associated group of public authorities have the entirety of the voting rights, that creates a presumption, and I don't accept it's a weak presumption. It is a presumption which has to be displaced by some special circumstances. And the practice of the matter comes into it in this way. You can displace the presumption arising from the possession of 100% of the voting rights, either, as happened in Carbo Termo, by showing that although you've got 100% of the voting rights, you actually have no power of direction, not even on a special resolution basis. Or you can, I suppose, displace it by showing that in practice the management was immune from control. That is what appears to have happened in Parking Brixton, although the report does not disclose what the particular factual matters were that led to that conclusion. But, my lords, what Coditel shows is that provided that we are talking about an entity whose controllers are all public authorities, the existence of wide management discretions does not matter if the membership is in a position to impose its will collectively, which in that case it was. In our case, the membership had the right to determine the contents of the rules, to appoint the directors, and, critically, collectively, by a Section 70, by 75% majority, to give a direction to the board. Now, my Lord, my learned friend's emphasis on practicality is directly relevant here. This is a consortium company whose purpose is identical to that of the generality of the members, because its purpose is to serve their interests in respect of insurance. There is therefore no inconsistency between the fiduciary duty of the directors to the company and the interests of the members. The provisions which refer to member directors as being representatives of members, therefore, notwithstanding the existence of the fiduciary duty, reflect the reality of the position. My Lords, finally and briefly, the function test. This test simply asks whether the supplier is also supplying other people. If the answer is yes, then the presumption may be that the relationship between that supplier and the public authority is equivalent to that of any market operator. So the function test will be failed. Now, that is what the European Court decided in the case to which my learned friend referred to this purpose, Asociación Profesional, the Spanish Correos case, which is at flag 24 of bundle 4. I won't ask you to turn it up, but the relevant paragraph is paragraph 62. Now, that case was about the status of the Spanish Postal Service, which had been turned into a state-owned private company, and it entered into a contract with the state to deliver the mails. The problem in that case was that in those areas which were not reserved to it by law, Correos also delivered articles like parcels and advertising matter under contracts with commercial operators who chose to use its services, a business which was conducted in competition with the likes of UPS, FedEx, and a host of other commercial delivery companies, so it failed the function test, just as the transactions in this case would have failed the function test if Lamel had insured other people than participating members and their affiliates. Ultimately, the only challenge that my learned friend puts forward to the application of the function test in this case is first the suggestion that Lamel may seek out business from other London authorities who are not yet members, and secondly, the inclusion of affiliates among the permitted assureds. Now, neither of those is in our submission relevant. The fact that Lamel may seek out the business of other London local authorities is in our submission beside the point. All public authorities who participate in a collectively controlled vehicle will, before their participation, have been the potential customers of commercial operators. My learned friend's argument would therefore involve distinguishing between collectively controlled vehicles whose membership was fixed at the outset and those which were in a position to attract new members in the course of its existence. There isn't a trace of any such suggestion in the authorities, and it is not possible to discern any principled reason why there should be. In fact, as your lordships will have noticed, in Coditel, the commune of Uccle was a potential customer of commercial suppliers, and it joined the consortium for the specific purpose of contracting with it. So it was in that position precisely. Yet the Belgian Conseil d'État found that the function test was satisfied. It is perfectly true that the European Court did not review or did not deal with that point. But if the Belgian Conseil d'État's view of the matter had been on its face contrary to the relevant principles of EEC law, then I submit it is not conceivable that the ECJ would have failed to point the fact out. Lords, as to affiliates, it said some will have significant assets. Your lordships will need, when considering affiliates, to remind yourselves of what is said in Mr. Phone's affidavit at paragraph 38, which deals with all of them. The position is quite simply that these are normally dealing with property like housing association property, which is actually owned by the local authority. And they are performing a management function there. The affiliates are people performing public functions under the umbrella of the local authorities. classic example, housing associations where the management committee of a separate entity are performing what would otherwise have been the functions of the local authority, purely public functions. And that's why local authorities are responsible for the premium, and local authorities must arrange the insurance, thereby sponsoring the member. Affiliates are simply people who may incur personal liability in the course of performing public functions associated with the local authority. My Lords, I've made my submission on references. In our submission, individual and collective control is the only real issue of EU law, and that is Act Clare in the light of Coditel. Commission and Germany, I should make it clear, as I thought I had already done, that I am not saying that this is a distinct principle. What I do say about Commission and Germany is that it throws a flood of light on the underlying rationale of the straightforward Tekal exception. The rest of this issue is all concerned with the application of the test to the particular facts, and that is classically a function for the National Court. My Lords, I apologise for overrunning. Those are my submissions.
Thank you very much indeed. Well, we're very grateful to all counsel on both sides for their help in this case, both in writing and orally during the past 3 days. We will take time to consider our decision.